The biggest mistake is that people don't clear their names before they start using them, meaning you want to do a full comprehensive trademark search to search all of the records of the PTO to be sure that there's nothing identical or confusingly similar to your name. And you also want to do a thorough common law search.
When you're launching a brand, it's easy to think about things like marketing, product development, and your brand's identity. This stuff is important, but something that's equally critical is actually trademarking. Welcome to the Scaling Emerging Beauty Podcast, a podcast that provides tactical tips and insights to help you grow your brand from 0 to 20 million. In today's episode, I'm joined by Lauren Bercuson, founder of Storylock Legal, and we talk all things trademarks and the important things that founders should pay attention to because this could make or break your brand. Some of the topics that we dive into include why trademarking for founders isn't optional, some of the biggest mistakes that founders make when trademarking their materials, how trademarks add massive value to your business over time, things to consider if your brand name includes your name and you want to trademark that, and also how to think about logos, slogans, and other things that are essential to your brand identity. This is a super fun episode, and I'm excited for you to hear what Lauren has to share. Let's get into it. As of the published date of this episode, I am an associate of Ulta Beauty. The ideas and thoughts represented here are my own and not that of my employer. Lauren, I'm so happy to have you on the show today. It's really fun to be talking to someone who is in this legal copyright attorney realm. It's one of those things that I think is often overlooked, but can end up being really important. So super excited to have you to talk today and share your knowledge base with my audience. Would love for you to just start off and tell us a little bit about yourself and specifically how you got into copyright as it pertains to like the CPG industry where I work.
Absolutely. So thank you, first of all, for having me. It's such an honor to be on your fantastic podcast today. My name is Lauren Bercuson. I am the founder of Storylock Legal, which is a trademark and intellectual property law firm based in Miami. I started practicing almost 20 years ago and started in the IP world immediately. I've always been a writer. I've always been a bit, more creative. And I loved the way that trademark law particularly allowed me to combine the logic and the creativity. So it was just an area that I fell into. I clerked for a while for an appellate court judge as well. Took a little detour when I had my kids to care for them, and then came back and started my own law firm. And my goal is just to help female founders, or really any founders, but I work primarily with female founders, protect their brands and lock in their legacies.
I love that. I do have a few friends that are attorneys, and I don't always hear about the creative side of being an attorney, but a lot of them are creative. So it kind of makes sense that this would be a really great option for you. So I love that, you kind of found your way there.
Yes.
So just for those who are listening, would love for you to start off with the basics and just letting us know what a trademark is and why it is essential for brands. Because oftentimes when I will even talk to brands, I'll say, this is something that's a nice to have, but it's not a necessity. But this is something that you need. So I'd love for you to kind of frame it up as to, is this trademark a nice to have? Is it a necessity? Do you think it varies a little bit based on the industry? Just talk to us about some of the legalities of it all.
Well, I, of course, am going to tell you that a trademark is a necessity. So let's start with the basics. Trademarks identify the source of goods or services. So in the CPG world, you see a name like, let's say Bobby Brown, right? If you hear Bobby Brown, you know exactly what kind of products you're getting. You can visualize the packaging, the source of the goods, right? And every trademark tells a story, essentially. You know everything about the founder, the messaging, everything. So basically, if you don't have a trademark registration, you don't own your brand name. And it's that simple. If you're using a mark without having first cleared it, right? To make sure that it's actually available for you to use. And then without filing a trademark application to get that mark registered, you have no real legal leverage. So once you own your trademark, you have leverage legally over anybody who begins using the same or a confusingly similar mark after you. This means that if someone starts using a mark that is too close to yours, all you have to do is show them your registration number, and essentially they have the burden to prove that they're not infringing. So it's a big source of legal leverage and ownership. Trademarks are also, they add a lot of value to your business. So let's say you're starting a company with the goal of selling it to, one of the big players in the industry. The more registrations you have, your name, your logo, your tagline, even colors, like look at, just as an example, Tiffany blue, right? The blue boxes. We all know Tiffany blue. The more trademarks that you have, the more source identifiers, the more value you have as a company if all of those marks are registered. So you also have the ability to monetize your brand if you have a registration. So there's a lot of things that you can do, not only, owning your brand, but ways that you can essentially exploit your registrations for monetary value. It's a necessity in that you want to own your brand, and then it's a value add to your company.
Thank you for explaining that. As I was listening to what you were saying, it made me think about some of these companies that get purchased. And it also made me think about Bobbi Brown, such an interesting example, because we all know Bobbi Brown Cosmetics, like OG Bobbi Brown Cosmetics from like the 90s, 2000s. But I found it interesting that Bobbi Brown recently came out with her own beauty brand line, yet again, Jones Road. And so that made me think, I wonder, with her trademarking and calling her original line Bobbi Brown Cosmetics, what challenges did that maybe pose as she was creating this, this new brand? And not that we need to necessarily speak specifically to Bobbi, but would love to just talk, generally speaking, what are some of the biggest trademark mistakes that you see CPG founders make? How can they avoid them? Like, is it wise to use something like your name as a brand? Does that limit you? If so, how does it limit you? Because I'm sure that there are also some benefits as well, right? If you're someone like a Beyonce, a Mariah Carey, some of these very famous folks,
right,
it might help to have that trademark associated with your brand. So I'd love to kind of get your thoughts on mistakes and watch house things to consider.
Absolutely. Well, it's funny that I've, of course, brought up one of the most complicated, brands. So Bobbi Brown actually sold the rights in her name. So she, as a business owner, could not start a new brand under the name Bobbi Brown. She would essentially be competing with herself. I mean, she sold those rights. So that is one of the reasons why her new brand is not under her name. It's under Jones Road. And I believe, and it's been a while, so I'd have to go back and look. I believe that she can use her name in connection with, public speaking and, certain, more like promotional things, events and stuff like that. But when it comes to cosmetics, she cannot use it. So it is an interesting point as to whether your name is a good idea. And again, it really depends because, look, not everyone's going to be Bobbi Brown, but everyone has a goal to be Bobbi Brown, right? But as I said, if you get big enough and you eventually are poised to sell your business, then if that business is named after you personally, then you could be, you could be challenging because that name is where all of the trust and authority has been and authenticity has been, is all in that name. So then when you sell it, you're selling your name and then you might not have rights to it anymore. So it's a toss up and it's a tough choice. Other common mistakes, people think all the time that just because they have a domain name or just because they incorporated their entity under a particular name, that means they own the trademark. and it's nothing of the sort. Just because a domain name is available, that has nothing to do with your trademark rights into a name. It just means that the URL was free, right? Same with business entities. There's no formal board monitoring those names. So as long as when you're registering your business that there's no identical name in that state's, or that state's business, those entity records, then you are likely able to register that name. Just because you registered your name, your entity name, doesn't necessarily mean you're using it as a trademark. So very different situations. Really the best thing and the biggest mistake is that people don't clear their names before they start using them, meaning you want to do a full comprehensive trademark search to search all of the records of the PTO to be sure that there's nothing identical or confusingly similar to your name. And you also want to do a thorough common law search, meaning you want to look at business databases, domain name directories, all sorts of things just to kind of give you the lay of the land. Because in the United States, trademark rights accrue based on use. So let's say that you, Monique, are using a name, right? And you go ahead and register it with the PTO because it was available, but you didn't really do a thorough common law search. And I'm using the same name across the country. My use predates yours. I can then stop you from getting your trademark registration. Because again, rights in the US accrue based on first use. So that's why anytime you are going to be launching a new brand, you want to clear and then protect your name. And you can even protect your name. You can file an intent to use application, meaning you can file an application while you're making plans to use your mark, even if you haven't launched your product yet. And this is the best thing to do to make sure that you're not going to get hit with a cease and desist letter, 10 months after you launch your brand, or when your brand is starting to become really popular because a few influencers picked it up and suddenly you're like the new Stanley, or what all the kids love, like that Summer Fridays, right? That was like huge here among all the middle schoolers. So that's why you want to make sure that you're in the clear. Because the worst thing would be if you were Summer Fridays and then all of a sudden you didn't clear your name and you go viral. Well, then someone else who's using Summer Fridays is going to come after you and sue you for all the profits you've made under this infringing name. And sorry, hopefully Summer Fridays has a trademark already in there. There's no issues there. That was just the one name that I know from my 12-year-old nieces.
No, that's too funny. And I would assume not, because I would even think that that's one of those things that's fairly important if you're moving into a relationship with the major retailers, having some of those things. Although I don't know that retailers necessarily confirm that. Like, I think when I was a buyer, I didn't ask about those things, but it is important. So what happens I was going to ask you about timing, like, what happens if you wait too long? I guess in that case, you then change your name. But what happens if conflict occurs? Like I'm operating under the name Monique Benoit. Someone else says, hey, I've been selling products under Monique Benoit, and so you can't sell anymore. Do you have any way to fight back? Do you then go back to, well, when did you start your business? Like, what does that look like? And is this just why you say just avoid this altogether by filing as soon as you have, you said like the intent, right, the idea of the name?
I mean, yeah, ideally you don't want that to happen because that is the biggest headache. And rebranding your business, once you've launched, once you've gained traction and momentum and made sales and you're building a following, is so disruptive. And the truth is it could all be avoided so easily for a relatively small investment. So when that happens, typically if you were not the first user and somebody comes after you, shortly after you launch and says that, you're infringing on their mark, you're going to have to stop. I mean, look, there are things that you can do. You can enter into coexistence agreements. But if I'm the senior user of a mark and I see you, Monique Benoit, using my mark, like let's say you start, using Storylock in connection for like legal something or other, I don't want you using my mark. So I'm not going to want you to coexist with me. I'm going to say, stop using it and give me the profits that you made under, my name because you're infringing. So it's really not a fun position to be in. And trademark attorneys offer packages to clear and protect your marks that are a couple $1,000s. That is nothing compared to changing your name, your website, all of your product packaging, all of your shipping materials, everything. When you think about it, your promos, your billboards, your this, it can be tens, if not hundreds of thousands of dollars. And it's so easy to be proactive and to avoid all of this. And that's the bottom line. So my goal as a trademark attorney is always to help founders just be proactive and protect yourselves as early as you can, because it's going to save you so much time and so much heartache down the road.
What if you're on the flip side of that, Lauren? Like, how do brands typically discover trademark infringement? Mm-hmm. And what steps might one take if you wanted to enforce it? Is that when you would get an attorney involved? When is it not worth it? When is it worth it to get an attorney involved? I'm just curious, just because I'm like, this is fascinating. And it also seems like this could potentially be a business idea for people who like to just mess with folks and ruin their lives. But I don't know. I don't know if it's like, are there people out there that are like, hey, I found out that this is not trademarked and you could make some money. It feels like in these days, that's a thing.
100% those people exist. And it still kills me. Like sometimes I'll call my mom and I'm like, Mom, how are people so shady that this is like what they do? It's like, I'm like still have like such an innocent and pure heart that like I can't take sometimes that people just are not honest and ethical. It kills me. But it's actually a great question, because as a trademark owner, right? So once you have a registered trademark, you actually have a duty to audit and enforce and police your mark. So many trademark owners have attorneys potentially, or they do it themselves, that monitor new applications filed within the Patent and Trademark Office. So if their registration gets flagged in connection with someone else's application. So if the PTO says to a new applicant, your mark is confusingly similar to, Lauren's existing registration, Lauren, will find out about that. So that kind of monitoring exists. And then there are just companies that will always, look at what's going on, Google searches, keeping up with all the influencers, keeping up with industry trends, publications, all of that. And then, if you see something that is potentially infringing, then people will coordinate with their attorneys. Or sometimes people will have their own letters and they'll start to try to work with someone without an attorney first to keep it a little friendlier. But then if need be, the attorneys will come in. And it's not fun, but the strongest marks, the biggest brands are the ones that aggressively monitor and pursue.
That makes sense.
Mm-hmm.
That makes sense.
Mm-hmm.
What about international trademarks or international expansion? If a brand is planning to expand globally, mm-hmm. obviously this discussion on trademark is specific to US law, but are there similar laws elsewhere? Are there things for folks to consider to have that protection internationally? I know I also am saying this knowing that there are many CPG, especially some of the bigger CPG houses, where they will have a brand that is one word in the US, one name in the US, and then in Latin America, it's another brand, and then they operate under another brand name, maybe in the Middle East. So I know that that is also true as well, but would love your thoughts on this kind of international expansion idea.
Yes. And that's another great question, because many brands, once they have established themselves in the US, are really looking to grow worldwide. And this is a tough one because, you have to make sure that your mark is clear in all of these other countries as well. And it's very complicated to get into, but there are certain treaties that the US is a part of, and there are ways that you can, easily, or not easily, but that we work with other countries and other foreign counsel to get your mark registered elsewhere. But there are instances where your mark is free and clear in the US and you may own it, but if you go to use that same mark in another country, your mark might not be available. And so there are circumstances where big brands have had to like change a letter or change a word to make their mark registrable in that other country. And it's also different because some countries, whereas the US is a first to use country, in that if you're the senior user, you have rights. Other countries are first to file countries, where if you file your application first, then you have rights. So it's really, that's why, it's a very
shady.
Yeah,
it's like, I've been doing this for 10 years and you just happen to file? Come on.
Right. So it's a very nuanced area, but this is why protecting your brand early is the smartest, most, proactive investment and proactive action that you can take to avoid problems down the line.
When you were talking earlier about trademarking and some of the different things, you talked about the value that trademarking can bring, specifically if you're looking to sell, trademarking your brand name, trademarking a tagline, maybe even a color. Can you talk a little bit about some of the benefits of trademarking beyond? Like if you said, I opened up and said, is this a nice to have? Is it a necessity? Break down for me what you would say is like necessity, trademark your brand name. When it comes to color, well, is that a lot harder? I would think that's a lot harder to trademark. Like Tiffany got it. I'm guessing they probably trademark like that color blue specifically with regards to jewelry. But like, when is it worthwhile to trademark a thing? When is it worthwhile to consider things? And then I also know trademarking is different from like a copyright. So I don't know if that's, if sometimes those are in the same realm, because I do know that sometimes is considered. So would love to get your thoughts on that.
Yes. Okay. So, we'll break this down. First, let's talk about trademarks versus copyrights, because that's a great, question. And it's one that a lot of people don't really understand. So trademarks protect the source of goods and services. So think about Nike, and we're going to use this example for the other questions as well. So if you see Nike, if you see Just Do It, if you see the swoosh, if you see Air Max or Dry Fit, right? You know that with all of those products, the source of those goods or services is Nike. So trademarks identify the source of those goods or services. Now, copyright, on the other hand, is a different beast. Copyright protects your creative works. So if you write a novel, if you record a podcast, if you paint a photo, or you write and produce a song, those creative works are all subject to copyright protection. So copyright protection attaches as soon as you create that work. So as an example, if you, like when you publish this podcast, it is already protected by copyright. But let's say that somebody takes this podcast recording and puts it on their own website and is promoting it as being, offered by this other company. If you, Monique, as the owner of this podcast, if you want to take action against that third party infringer, you must have a copyright registration. So you would have had to file an application to register those copyrights. So copyrights think your creative works. Now, sometimes, a logo. So let's talk like Mickey Mouse, right? Mickey Mouse is subject to copyright protection because it's a drawing, right? But Mickey Mouse is also a source identifier for Disney. So sometimes there could be copyright protection and trademark protection for the same element of a brand, but not always. So typically though, you think copyright creative work, trademark your names and your logos. Now, as to what is the most important, when clients come to me, I always start with baby steps, right? And I always tell them, like, if you walk into a lawyer and they tell you you need to trademark this and this and this and this, and you need to do it all now, like walk away, because you don't have to do it that way. You can start small and slowly build piece by piece. And that's typically the process that I walk my clients through. So the one thing that you should always do that I would say is your necessity that you want to do first is to trademark the name of your business as a word mark, not even as your logo. The reason for that is, okay, so as a perfect example, I'm Storylock Legal, right? When I filed my application, I filed for the words Storylock Legal alone, because when I filed my application, I had just launched my rebrand. I had just created my logo, and I wanted time to make sure that I liked my logo, that I wasn't going to have to rework everything. When you file an application and you register the words alone without any stylization, that means that you have full protection in those words, however you stylize them. So that gives you the broadest protection. If you file for your logo alone, right? And that's the registration you have. But then a year after you get your registration, you're like, ugh, this logo is just not working. We need to modernize it. Which happens all the time, right? If you want to revamp it, well, the second you stop using that, you retire your logo, well, now you've just lost all your trademark protection. So that's why I always say, if you're going to do one thing, the biggest necessity is to do the name of your business as a word mark. Now, other times people have logos that have acquired, tons of goodwill. So think of, the Nike swoosh, think of the NBC peacock, or Lululemon's, that swirly thing. Those marks, when they become so entrenched in the public's, in the knowledge base, that you see that mark and you know immediately who it refers to, then it's time. You want to make sure that logo is protected as well. And then, so those are usually the two biggest. First, always do your word mark, then you could do the logo. And then if you have a slogan that's really catchy, or, if your color becomes associated with you, like Starbucks green, Christian Louboutin, the red soles of the heels, those are trademarkable elements that might not be, a source identifier right when you start, but after a little bit, you're like, oh, wait a minute, this is taking off and this is a big deal. File your application and get that protected.
On the topic of changing your logo, right? Because many brands, to your point, undergo updated branding. Would you then say trademark both? Are you unable, if you have a brand name, you have Storylock, right? Storylock, let's say if you trademark the word Storylock, do you then automatically have the logo trademarked, or is that separate? And then that's where I'm asking, if you then say, oh, I want to change the look and feel of Storylock, do you then need to trademark the second look of trademark? You know what I mean? Not a trademark of Storylock.
So you don't have to is the answer. So if you are your business name and you've protected the words, again, you're protected however you use them. Now, you might not have protection in your specific design. So if someone comes along and uses a very similar design to yours, but not quite the same, and with different words, then you might not have protection in that. But if you have protection in your words and then also in your design that includes your words or may not include your words, then you'll be in an even stronger position. So do you have to register every logo? No. If you're really looking to build your IP portfolio, then heck yeah, go for it. Because again, each registration is just a value add to your company. Also, it looks good for investors if you're seeking funding. I mean, there's so many so many reasons that you would want to have those trademark registrations in your portfolio.
Got it. And it makes sense that it would be attractive to investors because from their lens, it's a matter of if someone tries to come up and copycat, there at least is some protection in place. Now, I'm going to go off script a little bit just because dupes are really popular, and this just popped in my mind. I was just thinking of a dupe that is very similar to a very popular body mist and fragrance. I'll just say that. That's kind of popular overseas. But we're hearing a whole lot about dupes, especially in fashion. It's been around for a while, but now it's moving more and more into beauty. What protection do these big name brands have? Is there protection when these dupes come out? Is that where it's like you can't really trademark a fragrance? You can't trademark a certain package because at the end of the day, a spray bottle is a spray bottle. And especially if you have different colors, representing the different fragrances, there's not much that you can do. So what protection do brands have to try to protect themselves, protect their IP, if you will, against someone else taking it and kind of knocking it off, if you will?
So there is something called trade dress protection, which is extremely valuable for CPG, for products. So I'm just trying to think, God, and when I was like in college and law school, there was a really popular perfume. I want to say, was it Versace that like the bottles were shaped like women and men?
That sounds like it. I think so. Mm-hmm.
So basically you can get trade dress protection in elements of your product that are ornamental and that don't have anything to do with the product's function. So another example would be, look at Veronica Beard, right? Her jeans, in the back where the belt loops are, rather than having all of the belt loops go straight across, like above your butt, for lack of a better way to, describe it, the belt loops make a V. And she has protection in that. So if another brand came along and started trying to use, those belt loops as a V, she could bring an action. So there are things like that, as another example, think of the bottle of honey that's shaped like a bear. That is a trade dress element. Anyone can have a bottle of honey, but if you have a bottle of honey that's shaped like a bear, everyone knows that those bears come from one source. So if you are trying to do the same thing, you're infringing. The Coke bottle, I think like the original Coke bottle used to have trade dress protection. So there are ways that you can protect parts of your, again, if your bottle is really unique, whatever it might be. Even like a Valentino perfume, if it has like some of those bottles have like the rock studs on them, right? Like like the glass is shaped like those. Do you know what I'm talking about? Like those studs.
Yes.
That, and I don't know if they have protection in that, but those are all things that have nothing to do with the function of the product. They're ornamental and they could be protected as trade dress.
Very cool. I think maybe less applicable for some of these more daily use products like serums and things like that, especially products where I always say if your bottle itself, like the vessel that's holding the product, if that's hidden, I typically recommend or say to brands like, is it worth it to add that extra, tooling or whatever? But fragrance is a category where the look of the bottle, the feel of the bottle is very much, it is ornamental. And in some cases, it's a part of the decor.
Right.
So very interesting to have that as a thought to consider, for brands that are in that category. It makes me think too, I wonder if like Monday hair care, like I'm thinking of some of the unique brands that came out and disrupted things with color or bottle shape. Like I wonder if they have trademarks out there, just curious and kind of.
Now I'm curious too. You're going to have to email me a list after so I can look them up.
I love that. Well, look, this has been such a great conversation. And one of those things that, again, I don't think brands always think of, but something that's definitely good to consider, especially if you are considering, again, a couple $1,000s to at least protect the brand name so that no one else can come in and operate. I always like to close out the podcast by asking my guests to share any advice they would give to founders. This can be specific to trademark basics. This can be in general, just as someone who is a fan of beauty. What advice would you give to an early stage emerging brand founder?
I would just say start smart. A comprehensive clearance search is the smartest thing you can do when you're starting out. Get your search, file your trademark application, and know that you are building on a solid foundation. I remember my first boss, so 20 years ago, telling me you would never build a house on land that you don't own because it's just way too risky, right? So the same way you would never do that, don't build a brand on a name you haven't vetted and that you haven't protected. Because if you don't own it, you're vulnerable. So I would say start smart, protect yourself, and do your due diligence, do your research. And sometimes it's hard when you get answers that you don't want to hear. I get it. I've had to work with many a client to change their name. But again, you're so much better off doing that in the beginning and building on something that you know you will own versus having to do it later when you're being forced to do it on someone else's time frame. There's nothing worse.
Oof, I can only imagine. Well, that's really good advice. And hopefully, this is a fun little FYI for those that are listening. I definitely learned something myself and know that for sure, a lot of the bigger companies, especially, they look at those things. I know this because I remember working with some of the bigger brands and hearing them say, oh, this is actually infringing on our trademark. And I'm thinking, oh, wow, but they have whole departments that do those things. So I know for smaller brands, it's a little bit different, but definitely good to at least lay that foundation so that you're good to go as you continue to operate.
Exactly.
Well, Lauren, thank you so much for being on the podcast. I'll make sure that all of your information will be in the show notes so that folks can find you. And then if there's anything else, they can always reach out there. And thanks again for being on the show.
Absolutely. Thank you so much for having me. It was an honor to be with you today. And I hope that your audience learned something, new. So this was great. Thank you.
That wraps up today's episode. Thank you so much to Lauren for joining us. It was so fun and insightful for me to hear about all of the essential things necessary when looking to trademark things related to your brand. I mean, it's tough to get free legal advice these days, so I'm very appreciative to Lauren. And remember, all of her details are going to be located in the show notes. And if you made it this far, thank you so much for watching. I appreciate you listening. Be sure to subscribe, share this with a friend or a founder, and I'll catch you on the next episode.